Well, good afternoon, friends. Thank you for joining us. I'm excited to be with you today for our third session of Among Friends, our virtual alumni speaker series. The purpose of this series is to provide informative and interactive digital sessions that showcase the knowledge and talents of our alumni. For those of you who don't know me, I'm Christine Pappas, Friends School Class of 2001. I'm the Director of Alumni Relations and Engagement here at Friends. And I'm delighted to introduce today's guest, Portia Wood, Friends School Class of 2002. Hi, Portia.
Hi, Christine. Thank you so much for having me. Hi, everybody.
A little about Portia. She earned her Juris Doctor degree from the University of Maryland in 2011, where she served as president of her class. She also earned a dual Master of Law and Letters from Pepperdine University School of Law, and she was awarded a bachelor's degree in journalism and Pan-African Studies from California State University, Northridge. Portia and her mom, Robin, who I believe is joining us today in the audience, who's also an attorney, own their own practice, Wood Legal Group. Wood Legal Group is an African-American, female-owned and operated mother-daughter estate planning law firm focused on fostering wealth creation and protecting generational wealth. Their desire to protect Black wealth through education, estate planning, business creation, and succession planning is the driving force behind this mother-daughter team's work. The firm's main offices are in Pasadena, California, and here in Baltimore, Maryland. They also service select clients in the DMV region. And actually, tomorrow, Portia is speaking to the Maryland State Bar Association regarding estate planning and the racial wealth gap. And Saturday, Portia is a panelist for the Greater Baltimore Urban League, and they're presenting Building Black Power with Generational Wealth. So Portia is a busy, busy lady. Welcome, Portia.
Thank you. Thank you so much. I'm so excited to be here and to be sharing with my fellow Quakers and really getting to give back to my alma mater. So thank you so much for asking me to come on. Estate planning is one of my favorite topics to talk about. So as I'm sure you can imagine.
And before we begin, I'm just gonna do some quick virtual protocols. We've done everything that we can to prepare and make this event a success, but we are at the mercy of technology. We are live, so if our Wi-Fi misbehaves, please be patient and we'll work to get it back on. In the event that we get cut off completely and are unable to resume the event, I'll send an email to everyone. And also this webinar is for informational purposes only. It does not constitute legal advice. If you seek legal advice, please consult a licensed attorney in your jurisdiction. And finally, if you have any questions throughout the session when Portia begins, we're going to ask that you use the Q&A feature that's at the bottom of your screen. And Portia will answer the questions at the end of the session. And we ask that you keep the questions general. There's no client attorney privilege in a group setting. So we will read the questions out loud and Portia will answer them out loud. So again, please keep them general. And now I will turn it over to you, Portia. I think I've spoken enough.
Thank you. Thank you so much. Yes, just to piggyback on what Christine said, we do want to make sure you get your questions answered. That's really the point. But general, people always go, but what about this thing? General, because we don't want you sharing private information about your family. All right, we're going to go ahead and get started. I'm going to share my screen. Let's fingers crossed that technology works. Success? Can you see that?
Perfect.
Excellent. So today we are going to be talking about what you need to know about estate planning. This is really a general overview of what estate planning is and how it works. We are not going to get into the weeds today, but we are going to identify really the 7 costly mistakes that people make in their estate planning. So what are the pieces you need to be thinking about for your own family's protection? Let's see, yay. All right, 2020, as Everybody on this call knows, I'm sure, has been an unprecedented year. We are moving into, is it the second wave, Christine? I can't even be sure of the COVID pandemic. Maybe it's the continuation of the first wave. Really not sure, but the COVID pandemic has impacted all of our lives around the globe. We are in the midst of a global health crisis that we haven't seen for over 100 years. And what we know about this is that it has put our health and our sort of own mortality on the forefront of people's minds. And a lot of the questions that we've been getting are, what happens if I get sick? People don't really know what that process looks like. And also, what happens if I pass away? Particularly people who have minor children. So we do a lot of education around what that process looks like. Additionally, we've seen some chaos since the election in the national government. And so we don't know that we have a really unified response. Also, we can't really be sure exactly what we're looking at going forward. Both parties' candidates have very different ideas about taxes and what that will look like for our ability to pass our estates is really going to depend on who's in office. How we plan for that is going to depend on who's in office as well. We've also seen this movement for the growth for Black lives. And in that, we've seen a lot of these disparities that exist in our country being really brought to the fore. And estate planning has, again, come up for a lot of people in that situation as well. So we're going to run through it. A couple of celebrity examples just to get your brain working, right? 2020, at the very beginning of this year, we had the tragic loss of basketball superstar Kobe Bryant to a helicopter crash. I'm sure most of you heard about it. But Kobe Bryant was with the Los Angeles Lakers his entire career. He was a businessman, a husband, a father to 4 beautiful daughters, one of whom unfortunately passed away with him in that helicopter crash back in January. What we know about Kobe Bryant's estate is that he had a comprehensive trust. Go Kobe. What we also know, and the reason we know he had a comprehensive trust is because of this part. We know that his youngest daughter, Capri, who was approximately 9 months old at the time of his passing, was not included in his trust. They hadn't gotten around to updating it because, you always sort of think you have time, right? Oh, we can do that tomorrow. There's no rush. We're not going to die in a helicopter crash. And so she wasn't included, and Vanessa Bryant had to go to the court in what should have been a private matter that nobody had any information about. Vanessa Bryant ended up having to go to the Superior Court of Los Angeles, and ask a judge for permission to have their youngest daughter included in this estate plan. And then wait months throughout a global pandemic for that judge to make that ruling to ensure that their youngest child was protected, even though that would have been Kobe Bryant's intent. As we've gotten to the end of 2020, that has happened and the judge has finally ruled, but it's taken almost an entire year for that to happen. So timely updating is really important. That's the lesson from this story. Second one is Chadwick Boseman. This one happened recently. Again, in 2020, Chadwick Boseman, for those of you who don't know, he played Black Panther in the Marvel movies, as well as the Black Panther movies, as well as Jackie Robinson and numerous other very prominent historical Black figures. He was an actor, he was a businessman, and he was a husband. He also filmed these movies for the last 4 years while battling cancer. And so he knew for years that he might lose this battle with his health, right? He went on to marry his longtime girlfriend because he wanted to make sure that she was going to be protected. But I'm not quite sure who was advising him, because recently she just had to file a probate in the Los Angeles court for almost $1 million. And that sort of says to me that maybe he had some estate planning and just forgot some assets. So this is either a funding issue or a lack of planning issue. But for some reason, his estate is now in the public eye and subject to court interference because either he did not fund something or he didn't have a proper plan. We see this a lot. Funding is one of the biggest issues why estate plans fail. All right, so now that we've done our celebrities for 2020, we're going to move on. Estate planning is an everlasting gift that you can give your family. The ability to have peace of mind, to have comfort, to have security is unmatched. And setting up a smooth inheritance is much easier than you think. Okay. Why do I do this? That's me and my tiny tot, who you might hear yelling in the background here. We do this because there really is a lack of knowledge. There is a hole, there's an information hole for the greater community. People don't know what they don't know. And estate planning is constantly changing. We've had at least 3 law changes that affect estate planning and retirement accounts. And most people don't even know that they've passed. We're going to talk a little bit about them, and then I'm going to encourage you to follow up with a financial advisor. So what are your planning options, right? First one, you can have absolutely no plan at all. If I thought this was a good option, we would not have this webinar. We'd be like, fine, no worries, right? It's also not exactly true. No plan really just means no plan that you've written yourself, because the state has a default plan for what happens with your assets after you pass away. So no plan really means no plan that you've written to protect and identify the people you want to benefit from you and how you want it to get there. Second thing you can do is a standalone will, and this can be a really powerful estate planning tool for people with lower assets. If your state threshold for a small estate, if your assets are above that threshold, a standalone will is going to be insufficient for avoiding court interference on your estate. What is that threshold? In Maryland, if your sole beneficiary is your spouse, that threshold is $100,000 gross. It's not that much, right? It's everything you own, regardless of how much debt there is. That's your cars, that's your house, that's everything, right? It's not that hard when you start counting up all of the different accounts that you have, retirements, et cetera, to realize that you are going to be above that threshold. And if you are, a standalone will is insufficient. If your beneficiary is a spouse and say children, then that threshold is actually lower. It's $50,000 in Maryland. Okay, so it's not hard to get there. Most people need more than a standalone will to avoid the court interference. The next option is really a legacy trust, a living trust. This I like to call a probate avoidance trust. What it does is it allows you to avoid the court interference, and then it distributes your assets outright and free of trust to your beneficiaries, which can be great for avoiding the court interference. What you lose is the ability to protect those assets going forward, which can be, it really is dependent on your goals. But from my perspective, I would say if you can add more protections to those assets, you probably want to at least think about it, right? And then the last option is sort of legacy wealth planning. Obviously, this is not a comprehensive list. There are things like irrevocable trusts and charitable remainder trusts, et cetera, et cetera. These are the ones that are the most common for average families, okay? Legacy wealth planning is multi-generational planning. It's planning not just for passing your assets to your beneficiaries, but for the generation beyond them. It allows you to lock in an estate tax exemption. And so passing that, you can also put restrictions and incentives and really sort of help to protect those assets grow over time for your family. And we're going to walk through how those work as we go along. 60% of Americans, approximately 60% of Americans, have absolutely no estate planning at all. We lose, as Americans, we lose the majority of our wealth at the generation transfer. It's approximately $2 billion annually is lost across this country in fees, not taxes, fees from going through the court process. By using the court's distribution system, we are losing, as Americans, $2 billion annually. It's a really expensive death, right? And that money is then coming out of our families' estates and being redistributed to all of the professionals who have to help them. So when we're going through this, I want you to not just think about, do I have a plan in place or the right plan in place, or do I have all these pieces, but also, do my parents, do my siblings, do my kids? And I do say kids, because if your child is over the age of 18, legally they are an adult. even if they are still in your pocketbook, which, many college students are, even if they are still in your pocketbook, they are adults. And if something happens to them, you no longer have the legal authority to make those decisions. So also thinking about your kids. First mistake that people make is they do not plan for unnecessary government interference. This is the court system, okay? We've talked a little bit about that, but I'm going to go through the two stages in which court interference can be incredibly costly for your family. One is a living probate process. This is if you are incapacitated. So someone has a stroke or commonly a car accident and they're in a coma, or current moment, COVID, and you get severe disease and you're in the ICU. If you are unable to make your own decisions and you haven't designated the person legally authorized to be able to make those decisions for you, your family will have to go through what is called a guardianship or conservatorship proceeding. Also, as we call it, a living probate process. They have to go to court. And they have to ask a judge for permission to be able to handle your affairs, to access your bank accounts, to make decisions for you. Now, people say to me all the time, my spouse, I said I do. Don't they get to do this? Isn't this their job since we got married? And the answer is no. Your spouse is not automatically your fiduciary. And it's important to remember, or at least let's put it this way. If I have a separate bank account when we get married, and I don't give you access to it while I have capacity, my incapacity would not automatically then give you access. That wouldn't make sense. That would actually encourage people to maybe do some nefarious things. That it doesn't make sense. And so if we leave the court in charge of making the decision about who's going to be able to have that level of power and authority, we are putting them in control. And they then have to be a bit paternalistic and make sure that the people they picked are doing a good job. So every year they're going to bring them back and say, tell me what you've spent the money on, give me a full accounting. Let's make sure that you're doing the right thing. Let's make sure that they're still incapacitated every year until you either pass away or you regain capacity. And if you're coming back every year, you're paying court fees, you're paying attorney's fees, you're paying accounting fees, you're paying conservator fees, and all of that is coming out of your estate because you didn't pick someone. Because on the front end, before you needed it, you didn't say, this is who I would want. And you left the court to make those decisions instead, right? This is a 100% avoidable process. The second is when you pass away. And if you pass away and you don't have documents in place to designate where it goes, there are the laws of intestacy that say what happens to your assets. But it goes through a court process, and the court can be incredibly expensive, right? To open a probate, particularly in California. I know we're sort of spread out all over the place on this, so I'm going to try to be general and then specific. But in a place like California, you have to publish the announcement of a probate being opened in a newspaper of general circulation for at least 4 weeks. And this is not an obituary. This is not them being like, oh, Portia Wood, she was such a wonderful person. She gave so much of herself. This is, we are opening an estate in the name of Portia Wood. If you think you have a claim against her estate, or you think you might be a child or a beneficiary, file your claim. You have this much time to do it. And people do. You know, people who are like, oh, she owed me money, I loaned her money. Or in the case of Prince's estate, for those of you, the artist formerly known as Prince, who then went back to being Prince because he won his lawsuit. You know, when he passed away without an estate plan, he also didn't have any children. His 2 children that he had died. One of them only lived until about 3 days old. And so he didn't have any direct beneficiaries that were his kids, but multiple paternity suits showed up against his estate. And people said, oh, my mom said she and Prince had a fling in the 70s. I think he's my dad. The estate has to then investigate whether or not those claims are true with paternity testing and X, Y, and Z. And that is all money that's coming out of the estate to fight these claims, right? So it just opens it all up. The executors and attorneys get paid by statute. It is a formula based on the gross value of your estate. In California, and I'll continue that example, but in California, if your estate is gross value $1 million, the attorney's fees and the executor fees by statute are $46,000. And that might not seem like that much. You're like, oh, I've got $1 million, but 46, oh, that's not terrible, right? But it's gross value. So if you have $1 million estate, but you've got $700,000 in a mortgage, you only have $300,000 in equity. And 46,000 of that is going to attorneys and executors. Now you're cutting into large chunks of what's available because you haven't even added in court fees or attorney's fees, accounting fees, etc. If you have property in multiple states, you will then have to have a probate in every single state because probate is a function of state court. A Maryland court cannot deal with California property and vice versa. And so you would have to then start this process, or your family would have to do this process in all of these different places, which also means that they don't get any access to those resources until the probate has closed. And in probate, they pay court fees first, right? Court is always going to pay themselves first. And then your secured creditors get paid second. Your attorney and executor gets paid third. Your unsecured creditors get paid fourth. And your beneficiaries get whatever is left over. That's the process. And the court's in charge of selling real estate or selling assets to make sure that these other things are paid, which is a huge opportunity cost for your beneficiaries. So, second mistake that people make is unnecessary taxes and fees. I know I talked about it briefly in the beginning, but having the wrong selections on your IRAs and 401ks can cost your family a ton. In December of 2019, Congress passed the Secure Act, which changed the way we deal with retirement accounts. It said that people who are earning earned income can continue contributing to their retirement accounts until 72. Go you guys, right? Which means you can continue to add money without having to take those distributions right away. Your spouse would still inherit the same. Where they made the biggest change is when it passes to the next generation. So if you then intended for your kids to get it, that's where the change comes in. We used to be able to say, oh no, I don't want to take that out, which was the right move, right? I don't want to take that out. I want to roll it over into an inherited and get a lifetime stretch, which meant I could do mandatory minimum distributions up until I hit the age of having to take mandatory maximum distributions. And depending on how young I was at the time I received this inherited retirement account, that time would allow it to grow. So if I got $100,000 at around 20 something years old, by the time I hit mandatory maximum distributions, that would likely be worth about $1 million. That's a big increase because that money has grown tax deferred or tax free. And by the time I start taking it out, when I'm older, I'm in a different tax bracket, presumably, right? Because maybe I've retired at that point. And so my taxable income is much lower. What that change did is you no longer have a right to a lifetime stretch. We now would have to take out the full retirement account within 10 years. And what that says for most of your kids is that they are likely going to be in the highest tax bracket, which means A, that money has not gotten enough time to grow, and B, it's going to be taxed at a much higher rate. There are opportunities for minimizing this. And this is why I say talk to a financial advisor or wealth manager about that. To see about, do you move it into another asset category? But if you didn't know that in 2019 that happened, you need to have all of your plans reviewed. 2020, we also had the CARES Act, and in 2018, we had an entirely new tax code or tax plan that came out. So all of these things require looking back at your financial strategy and making sure it's still in line with the current laws. Number 3 is nursing home protection. This is the one where people sort of laugh at me a lot. They're always like, I don't need a nursing home. My kids are going to take care of me. The reality is that most people do, right? 63% of people over the age of 65 need some form of care before they pass away. The average amount of care, or average time, is about 2.5 years. And so most of us will find ourselves down the road needing some form of assistance. And our generation is now affectionately deemed the sandwich generation, because we are not only raising young kids, but we are also then caring for elderly parents, which has a huge economic impact on our ability to build and save, which means we are looking to our parents' generation to supplement us with an inheritance. because we're not able to build for ourselves. So no nursing home protection can actually be catastrophic. The cost of nursing homes, right, in Maryland is $105,850 per year after tax dollars. That's the average. It's more than $8,821 a month after tax. Most people's estates cannot afford that once they are no longer earning an income. They just have not planned enough for retirement. And so when we start to look at what those costs are, we have to make a plan on the front end. So how do you pay for long-term care if you need it? One, you can use your own money. I do not recommend using your own money, right? Because then you don't have any more money, and that's never fun. The second is you can buy long-term care insurance. This isn't my favorite option either. I do think people should have some form of long-term care, but standalone long-term care products are few and far between, and they're incredibly expensive. The premiums can go up every year. And if you don't end up becoming incapacitated and you just pass away, you've spent all of this money and there's no benefit left. I do know that there are these hybrid products now where you can get, life insurance on one side and long-term care on another. You'd need to talk to a life insurance agent about that, but they do exist and they're worth looking into. They're being touted as these, sort of guaranteed use products, right? Either you pass away and there's a death benefit, or you get sick and you have a long-term care benefit. But if you use the long-term care, you no longer have a death benefit, right? So it's one or the other, but at least there's something for what's going in. You'd have to talk to a life insurance agent about that, but it's important to know that that's an option. Third way is to apply for limited Medicare benefits. This is a max of 100 days. Only the first 20 days are paid at 100%, and the remaining 80 days are paid at a fraction. So this is not going to be enough coverage for people, right? The next is to become eligible for Medicaid benefits. And just in case we have anyone on here who's from California, it is called Medi-Cal in California. It is Medicaid everywhere else in the country. It is essentially exactly the same program. California just has to dare to be different and get Cal somewhere in the name, but it is basically the same program. To qualify for Medicaid or Medi-Cal if you're in California, you have to pass a means test, which means you have to spend all of your own money first. You have to be broke. You have to be under the threshold for the state benefits to then kick in for your care. They will not, though, fun fact, take your family home. It's nice, right? So you spend all of your money and only one parent has to go into a nursing home. The other parent can continue to live in the home. What's not so nice is that once both pass away and that asset is getting ready to move to the next generation, a bill is presented to the estate for everything the state has paid for the care. And it's called a Medi-Cal recovery program in California or Medicaid recovery program anywhere else, where they will then force your beneficiaries to refinance that asset and pay off that debt, or the courts will sell it and pay that debt and give your kids whatever's left over. We know that real estate is a wealth generating asset. And so leaving the court in control of that asset is incredibly problematic, right? There are things like Medi-Cal planning. We do not have the time today to go on that deep dive, but it's important to know that there are Medi-Cal and Medicaid planning trusts that can protect those assets and not require you to spend all of your money. It's something that you have to talk about if that's a concern. The last is qualifying for veteran aid and attendance benefits. And these are really specific benefits, but if you do qualify, they can be incredibly helpful for preserving an estate. So the fourth mistake, and Christine, how am I doing on time? I'm trying to talk really fast.
We're getting through it.
Okay, I'm gonna speed it up. So no divorce, creditor, and lawsuit protections for beneficiaries or heirs. This is really that legacy part, right? The other pieces were in the beginning. Once we get to that death time and the assets are passing to the next generation, it's, do we give it to them outright? Or do we put some divorce and creditor and lawsuit protection on those assets for that next generation? And what does that really look like? Lawsuit expenses. if you are thinking about your beneficiaries and they are prone to accidents. And we got to be really clear with ourselves, right? I know we all love our kids and they're all the same, but they're not all the same. And some of our kids like to drive really fast, and perhaps, they might get sued. And if they do that, do we want the assets we've left them to potentially be attached in a judgment? Nope, right? Are they in a profession that's often sued? Surgeons get sued a lot. In fact, we have a specific trust made for surgeons just to help protect their assets. Police officers get sued a lot. Contractors get sued a lot. And so do you want the assets you've left your kids to be potentially caught up in a lawsuit related to their profession and their work? Or do you want them to be in a separate bucket, protected off to the side, so that whatever happens in their lives is not affecting this bucket over here, right? The other thing to think about is judgments. And we have to be really sort of clear with ourselves, do our kids have child support judgments, right? And sometimes that comes from divorce or for whatever reason, but if it's there and you leave assets to that child outright, the only thing that's going to happen is they're going to get attached to satisfy these awards. And what could have been left for the benefit of your child and then their child has now been circumvented by the child support office. They've processed it. They've taken all of their fees out. And what actually gets to your grandchild is significantly less than what they would have gotten if you had just planned for it on the other side. And so we have to look at who are our beneficiaries and what do they need. Student loan debt is another big one that comes up a lot. If we drop money into our children's estate and they have student loans and they're on an income-based repayment or anything like that, we've now increased their net worth. Income-based repayment has to be recertified every single year to show that what your payment should be. If we increase their net worth, we've now changed what that income-based repayment is going to be by just giving it to them outright. And if that happens, our children or our beneficiaries are going to end up with higher payments to the government that it's just going to come out of your assets because we didn't plan for it well. And we don't have to. We can put it into another vehicle, a trust for their benefit, but not theirs, that then can protect them on the other side. But we have to think about it. Not all of our kids are the same, and not all of our kids need the same, or beneficiaries need the same things. Financial immaturity. Are they ready for a large lump sum distribution, and will they make good choices with it? A lot of people say to us, oh my gosh, I really just I think that they don't understand money, or they don't understand the value of money. And it's true. And we really want to encourage people to think about, do your kids know anything about money? Not just how to spend it and a dollar is, a dollar, right? But if you drop, let's say $100,000 on your kids and they owe $100,000 in student loans, would you want them to take that $100,000 and pay off that student loan at that has a 5% interest? Or would you want them to take that $100,000 and make an investment somewhere that's getting them a 10% return and continue to pay the monthly that's only at a 5? Because even though they owe 5 over there, they're making 10. But if they pay it with the money you give them, they owe 0, but they have no more money. And so really thinking about, what do we do with the assets once they get there to continue to ensure their growth takes a little bit of forethought on our part to protect them from themselves. Mistake number 5 is failing to make your wishes clear. This one is really, really common, and it's not so much about money. This one is more about stuff. Mom's wedding ring, or the family heirlooms, the things that there's only one of that cannot be divided, that people may have sentimental attachment to. It is very uncommon for beneficiaries to come in and argue against a dead parent's wishes, right? If mom says, I want daughter to have this because it always reminded me of her, or when I bought it, I thought of her, or, I just can't wait for her to bake with it with her own daughter, whatever the reason is, the other kid's not going to come in and be like, but I baked with her too. They're gonna be like, oh, that was so sweet, because they have something to connect with, right? Number 6 is really legacy protection. Money is one thing, and money is sort of the baseline of estate planning. We want to protect your money. We want to minimize your taxes. We want to make sure it gets to your kids. That is one part. But I take a more holistic approach in our firm, my mom and I do, where legacy, who we are as people and why we do things, our values, how we've gotten here, what we've learned, and what we don't want our kids to learn by action instead of, we need to pass that on. I am the beneficiary of good legacy planning, right? My great great grandfather was born here in Montgomery, Maryland. He was the son of the slave owner. He obviously was not acknowledged or a part of that estate planning, but he was allowed to work his own garden and sell his own vegetables on the land. He then used that money to purchase a portion of that land from his father's estate. His aunts, in essence, sold him a portion. He then used that money to buy his wife's freedom and all of his children's freedom. Eventually, he amassed about 600 acres of the former land that he and his family were enslaved on, which was also his father's land. It all gets very complicated. And when he died, he divided it up amongst his 4 children, my great grandmother being one of them. She sold her portion to her brother and gave that money to her husband, who founded the Afro-American newspaper, which is the longest continuously running newspaper, African-American newspaper in the country. We know their stories because they wrote them down. We know that founding the Afro was important to them so that there was someone who was telling our stories, who was celebrating us, but also providing educational opportunities and work opportunities where none existed. And that when they acquired more knowledge, that they felt it was their obligation to continue to share it with the community. And I know that 140 years later, that is still how I carry myself, because I know that those are the shoulders that I stand on. So when I realized I had more information in this arena than my contemporaries and 60% of the population, I knew that I needed to continue to share that information so that we could all do better. But that's because they wrote it down. I knew the shoulders that I stood on. And so we think that that is equally as important as passing on wealth, because wealth without direction, we know, is lost within 3 to 5 years. Inheritance given without any restriction or setup is lost within 3 to 5 years. And so it cannot be the only thing that's valuable to us. Finally, is forgetting about remarriage protection. Yay. Everyone says to me, if my spouse dies, I'm never doing this again. I'm never getting remarried. I'm done. I will just be a spinster. Like, I'm never doing it ever again. And statistics tell us that's not true. In fact, we have a lot of blended families. 51% of marriages end in divorce in this country. And then you start to think about, people passing away, X, Y, and Z. Life is for the living. And people typically do not stay single or alone, right? And it's not a problem. I mean, it's not a judgment, right? It's not a problem to do remarriage. What we do have a problem with that needs to be considered is that stepchildren cannot inherit from step parents under the laws of intestacy. So if you were to get remarried and start combining in this new union and you die, your children can't inherit from your spouse, absent an estate plan. So let's do a scenario. I get married to this person and I've got Emerson over here. We build together. So now we have marital assets, or depending on if you're in a community property state, community assets. I pass away, my spouse gets all of the assets. My spouse passes away, Emerson is not their beneficiary absent an estate plan. So Emerson has now been disinherited. And if we don't have any kids together and they don't have any kids, they'll look up to see if their parents are still alive. And if their parents aren't still alive, they'll look out and see if they have any siblings or if they have kids, et cetera, which means that the house and all the assets that we built together didn't go to the son that we raised, but now to distant cousins that they might not have known. And it's all because people don't think about the fact that stepchildren and non-biological children who are not adopted are not considered under the laws of intestacy. You must have an estate plan that specifically names them. 2 people who are married who both have kids from separate unions are in a race for the first to die. Whichever one dies first, those kids get disinherited. I mean, there's no other way to explain it, to simplify it. Like that's how it works. And so if you are in that situation, you have to consider them. You must do something proactive. So what are the summary of an ineffective plan? No living or death probate protection. That's really your court interference. No nursing home cost protection. That's making provisions for allowing a successor trustee upon your incapacity to make plans for nursing homes, right? Lawsuit creditor divorce protection for children and beneficiaries. I think that's the biggest one as it relates to protecting wealth generationally. Remarriage protection, blended families, it's incredibly important. There are too many stories where people end up with the family home has now gone to someone else who has no attachment to it. Retirement plan protection. Please talk to your wealth managers, financial advisors. If you don't have them, we have recommendations all around the country, but you want to talk to someone. No protections with the do-it-yourself and bare bones plans. A lot of that is dealing with funding. And last but not least, not preserving your life values and your stories and avoiding the family feuds. Because the moment your family starts feuding, they're going to go to the court to ask for them to resolve the dispute. And once the court goes in, you're now back to number one, where you have this court interference. So what's most valuable to you? People tell us it's family, it's friends, it's their health, it's their experiences. It is very rare that people will say that money is the most valuable thing to them. On another note, talking about money, there is something called charitable planning. You can do charitable planning in your estate plan, which can allow you to get tax benefits while you are alive on the planning that you've done to support some of your favorite organizations, right? So if you're inclined to continue to support organizations after you're gone, you can do that in your estate plan and get tax benefits today to help reduce your taxable income today. And then you also get to leave this legacy that continues long after you're gone, that people can look back to and really be lauded as a good steward. So I got Friends up there because Friends is a charity and you can support them. But really the question becomes, what legacy will you leave, right? And what we know is that 60% of people in this country leave behind court hassles, unnecessary fees, taxes, families disputes. But those things are avoidable, and you can leave behind planning that works and really create a solid financial foundation for the generations that come beyond you. So I hope that this was helpful and valuable. Thank you so much for joining us. And any questions?
Portia, thank you so much. That was, I have got a preview, but there is a lot of information in there, and you do an excellent job of explaining it.
Thank you. Okay.
Let's go to some questions. Let's start with the first question. At what age or what life changes would you say should prompt people to make an estate plan?
Yeah, so everybody over the age of 18 needs an estate plan. They just don't need the same estate plan. So someone who is 18 with no kids, no house, probably just needs a simple will and their living probate documents, so that if they ever got sick, there's someone legally authorized to step up and they don't need to go to court. And if they were to pass away, there's a document that distributes their assets. It's a very simple estate plan. That would essentially be the same thing for any adult over the age of 18 that is below their state's threshold, doesn't have minor kids, and doesn't own a home, right? When you have new kids and you've got minor children, you not only have to think about how do I get them my assets, but who's going to be financially responsible for those assets until my child becomes of a certain age, and how do I continue to incentivize my children long after I am gone? Because the only thing that will be left for them is money. So when you have new kids, you want to consider that. If you have special needs beneficiaries, your planning for them is very different. And I know we don't have a lot of time to talk about that, but if somebody becomes special needs in your family, you're going to need to update your planning. A good way to think about your estate plan is that it's a living, breathing document. As your life changes, your plan is probably going to change with you. You know, as your kids go from minors to adults, you're probably going to plan for them differently. When they start their own families, you may update your planning again. We review plans with our clients every single year. And really, it's just a very simple sort of, has anything been updated? Has anything changed in your life? Every 5 years, they've got to sign new powers of attorney. So your living probate
Okay,
documents.
next question.
Yeah.
Do we set up a trust with an attorney or a financial advisor?
An attorney. Your financial advisor is really for discussing retirement assets. We work together with financial advisors and wealth managers and CPAs and real estate agents. Why? Because your real estate agent's probably going to sell you your house. Your CPA is helping to deal with your taxes, right? Your financial advisor is the one who's really getting you to retirement, making sure that you have enough money. They're setting up those structures. And we are doing the legal structure for all of it. And so we are encompassing everything else that they are doing. But so for your trust, you're doing it with an attorney. For your IRAs and your 401ks, you're doing that with a financial advisor.
And we're getting some questions about what you offer, Portia. And I mentioned in the beginning, you are licensed in Maryland. You do have a practice. I mean, you are part of the Maryland State Bar, right?
Yep.
And I think we're going to offer 15-minute calls as a follow-up to folks who attended this session, correct?
Yes. Yep.
And a specific question is, do you offer family estate planning sessions, like for the family?
Absolutely. I mean, we work multi-generationally. There's a lot of people who like to do common pots. And so, yes, before I get too deep into the woods, yes, the answer is yes.
So you can advise in Maryland and you do family sessions. And for those folks who attended today, in my email follow-up, I will share the information for a starter phone consultation that Portia kindly offered.
No worries.
Let me see.
So I'm like looking at all these.
We have a question about the moral argument about minimizing taxes, like if that should be the goal or not.
So that really depends, right? So the moral argument for minimizing taxes, I would say that yes, people should pay their fair share of taxes. The challenge that comes in here with estate planning is that in 2018, Donald Trump doubled the federal estate tax exemption. And then it was indexed for inflation. So federally, people can pass, what is it, $11.57 million estate tax free. I think in 2021, it'll go up to $11.78 million estate tax dollars estate tax free federally. And what we are seeing is that despite the fact that these taxes are so high, that the tax exemption is so high, average Americans who are nowhere near that amount of money, because they do not have an estate plan in place, are ending up losing large swaths of what they've worked for through the court process, through fees, et cetera. And what we also know is that you can lock in that exemption as it exists today on a legacy trust for the 2 generations that are beyond you. So if you only have a $2 million estate, federally, you still now have about, $9 million left in an exemption that you could pass to your kids to be able to pass to their kids later on down the road. It's not so much minimizing taxes as much as it is preserving the exemptions that already exist.
Before we get to, I think we have 2 more questions,
Sure.
But you're getting shout outs from our guests about how wonderful this presentation was and how informative it was. So I just have to pause and say that. Thank you.
Thank you.
Patricia. And so next question, what problems might still remain if you have a revocable trust? It eliminates most of the problems that might happen in the probate process, correct?
If you have a properly funded and executed living trust, you will avoid the probate process. So you won't even have to go to it. The examples that we showed in the beginning with the celebrities is Kobe Bryant ended up having to go, his estate had to go back to court because of not timely updating. He had a new child that wasn't considered or contemplated under their estate plan. And so they had to get permission to get her added. It's not a full probate process, but it really is an example of why you do need to do timely updating when life events happen to make sure that your plan is still going to work for what you need to do. The other biggest issue we see is funding, which is sort of the Chadwick Boseman example. I only say that because I do not believe that his estate was only worth $900,000. I mean, his role in Black Panther alone netted him significantly more than that. And so I can only assume that there is a trust somewhere that is holding the remainder of those assets, and that $900,000 that's in the probate court was left outside, was not properly funded into the trust that exists. That's just my belief based on what I know about the income that he's made. Funding is a huge issue that essentially, if you do not properly fund your trust and keep it funded over time, you basically have a gigantic paperweight. It doesn't protect anything if you don't put things in it. And funding is the actual transfer of title to assets. One way to know if your assets are funded is what name do they come in? What's your tax bill in? If your tax bill comes in your personal name, then your home probably isn't deeded into the name of your trust. That's going to have to go through a probate process to get title changed to your trust, versus doing it while you're alive. I guess, hold on, easiest way to think about it. If it's in your own name, once you die, nobody has the legal authority to take it out of your name. The only place that can take it out of your name once you are gone is the court. And so if you transfer title while you are alive, once you pass away, your trust survives you. And so you no longer need to go to a court to get title changed, because you've already empowered someone to step up and make decisions on those assets. And by make decisions, I mean distribute them however you've designated. You don't need a judge's approval because you've already done it.
Okay, last question. This will be a combo.
Okay.
We've already mentioned that what we're going to offer for you, Portia, but how would one find an estate planning attorney, perhaps, if they were just looking for one? And how much does it usually cost to work with an estate planning attorney?
Ooh, good questions. All across the board, right? So in terms of prices are all across the board. What I would say is, when you're looking for an estate planning attorney, you want to know how much continuing legal education they do on an annual basis, and not broadly, right? Because most bar associations, with the exception of Maryland, which doesn't require any, Maryland is like one of the only states in the entire country that doesn't require any. But California requires 32 hours of continuing legal education every 3 years. And that's across the board. It's in ethics, it's in bias, it's in all of these things. We are members of the American Academy of Estate Planning Attorneys, which actually requires its members to do 36 hours of CLEs every single year, specifically in elder law, tax law, and estate planning, which means it's not enough to cover our bar requirement, depending on what state you're in. So it is specifically focused. You want someone who is specifically focused in this area, because the law and the strategies are always changing, right? I named 3 law changes that just happened in the last few years. And we know with a new administration coming in, that we are probably going to start to see even more changes all around the board. And so you've got to have someone who's going to stay on top of that. Also, what's their follow-up process? If the laws change, is the requirement on you to keep up with that and contact them? Because for most people, that's the way they do it. They say, okay, we've created this estate plan. The staying on top of it is your job, and we're here to help if you want us, right? So you want to know what the follow-up is, because if they're going to call you or send you an email and say, hey, this law change just happened and we think it could impact you, you might want to come in and let's talk about it. That is a huge benefit. I'll just use this as an example. On Friday, Prop 19 passed in California, and it was too close to call, which is why they just called it on Friday, right? Prop 19 is dealing with inheritance tax on property. It's repealing the one-time parent to child or grandparent to qualifying grandchild tax reassessment on property. It's a huge deal, and it's going to negatively impact most low-income communities because they don't have the resources to do estate planning, right? But and there's a 2.5-month window before this law takes effect, that people have an opportunity to make some changes. if you do not have an attorney who's going to reach out to you on Friday and say, hey, this law just passed and it's going to have this negative impact, we need to talk about what your goals are and what makes sense, you'll miss the window. And once it's gone, you can't get it back, right? So I would say paying more for the person who's going to keep you updated is worth its weight in gold. And so it just depends. You'll find people who'll be like, I'll give you a document for $1,000. And you'd be like, I saw a trust that was 5 pages long. And I was like, I don't know how you get all of the things that you need in 5 pages. Our standard trust for a single person is about 78 pages long. I'm like, I don't even know how you do all of that. So it just depends, right? And I would say CLEs, follow up, what are you getting, right? That's going to be the really important piece. I actually have a whole list that I can share with you, Christine, sort of what to ask an estate planning attorney, and the answers that you get should really help you sort of determine it. Also, it should be a long-term relationship. So you should like the people that you are talking to, because you want them to know you, know your family, know your plan. And as you make updates, be able to, sort of work with you through that. So, are they getting ready to retire? Right? Because what's their succession plan if they are? Making sure you know all of those pieces. But yeah, that would be how you find an estate planning attorney. And then cost is really all over the board. On average, for a trust-based plan, we find that most of our clients are between the $3,500 and the $5,500 range.
Great.
Yeah.
Portia, thank you again.
Yeah, you're very welcome. Thank you.
It was so wonderful. And thanks to our audience for joining us. And I will send a follow-up email. And Portia, I hope we see you soon. And good luck with all your presentations this weekend.
Thank you. Wait, someone did an anonymous thing. A good resource for estate planning attorneys in Maryland is the Trust and Estate Section Council of the Maryland State Bar. 100%. In fact, I am speaking for them tomorrow if anyone wants to jump on. But yes, that is 100% a great resource for estate planning attorneys in Maryland. And then again, just ask them those sort of follow-up questions and then pick the one that works best for you.
So that's the Trusts and Estates Section Council of the Maryland State Bar. Great.
Yes, ma'am.
Okay. All right. Bye.
All right. Bye. Thank you so much.
Okay, bye-bye.